Excited to moderate this panel. My name is Neil Chilson. I am the head of AI policy at the Abundance Institute. I am a computer scientist and a lawyer, and so artificial intelligence and the law is literally my sweet spot. It's what I work on, and I'm very excited to have a great panel here to discuss two very interesting papers. Our panel is titled Past as Prologue, How Will Generative AI Disrupt Our Approaches to Competition Policy and Our Copyright System? And here we have two papers, one by Roger Alford, who's a professor of law at Notre Dame Law, and one by Zvi Rosen, who's the assistant professor of law at the Southern Illinois University Simmons Law School. Joining me in discussing and commenting on the papers is Robin Feldman, the Arthur J. Goldberg Distinguished Professor of Law and Director of the Center for Innovation at UC Law San Francisco. Each of these participants have extensive and impressive CVs, but we only have 30 minutes to talk about two really complicated topics, so I will refer you to your favorite search engine to find out more about them. They're both they're all very Googleable. So each of the authors will give a brief summary of their paper, about 10 minutes. We'll have, after each summary, we'll have discussion, comment from me and Robin. And then at the end of all of that, we'll have some time for questions from the audience. Well, we'll have response time for each of the authors, and then we'll have, at the end of all of that, some time for questions from all of you. So again, our time is short, so I hope the participants will not be too upset if I gently remind them if we get at time, but I know I won't really have to. So let's turn it over first to Roger. You have 10 minutes to talk about your really interesting paper.
Great. Can you hear me on that? Thank you. This is better. Thank you. So I'm here to talk about the competitive landscape of artificial intelligence, and let me just start with preliminary comments about the opportunities and the perils of artificial intelligence. There's a wide spectrum of views about AI and its potential, literally from the utopian views to the dystopian views on what the future holds with the development of artificial intelligence. Today, the Nobel Prize in Physics went to the founders of artificial intelligence, John Hopfield and Geoffrey Hinton. And it's quite notable that Geoffrey Hinton said that a part of him regrets his life's work. And he says there's just no way to prevent bad actors from using AI to do bad things. And so he regrets his entire life's work about developing artificial intelligence. And he resigned from Google as a consultant so he could speak more freely about the dangers of artificial intelligence. I thought that was pretty interesting. The CEO of Microsoft's AI, in his book, The Coming Wave, says the potential benefits of these technologies are vast and profound. With AI, we can unlock the secrets of the universe, cure diseases that have long eluded us, and create new forms of art and culture that stretch the boundaries of imagination. But the potential dangers of these technologies are equally vast and profound. With AI, we could create systems that are beyond our control and find ourselves at the mercy of algorithms that we don't understand. We are faced with a choice between a future of unparalleled possibility and a future of unimaginable terror and peril. How has the government responded thus far to AI? Well, with respect to regulation, it's been very mixed. The Biden administration has issued a controversial executive order addressing artificial intelligence that seeks to promote competition in emerging AI marketplaces, among other things. But there's been absolutely no bipartisan support for that executive order. Especially proposed regulations that may entrench incumbent power. And there's been a lot of controversy about the EO from, in fact, the Republican agenda. The only negative thing they said was we're going to repeal the EO that Biden proposed on AI. However, there is strong bipartisan consensus that emerging AI markets present significant competition concerns and that government antitrust authorities should closely monitor emerging AI technologies to ensure that big tech companies promote competition and do not violate antitrust law. So my article focuses on four things. The upstream aspect of AI, discussing the essential inputs for generative AI development and big tech's ability to exert itself into the value chain by controlling those inputs. Second, it focuses on the downstream aspects of AI, discussing examples of how big tech's control of end-use applications by integrating their own AI applications into their ecosystems. It then addresses the most salient antitrust concerns that have arisen with emerging AI markets, including antitrust scrutiny of mergers and acquisitions, alternative investment arrangements to skirt merger review, abuse of monopoly power, and algorithmic price fixing. And then finally, fourth, my paper addresses a discussion of the relationship between competition law and national security, and particularly efforts to ensure that AI technology does not end up in the wrong hands to pose a national security threat to the United States. So first, the upstream inputs. Big tech companies have natural advantages with respect to AI. Among the essential inputs necessary for competitive AI deployment are the developmental frameworks, the data necessary to do the training, compute infrastructure, which includes not only the GPUs, but also cloud storage as well, and then finally the talent, the sort of broad talent necessary to do the training, but then also the very, very specialized talent to do the sort of so-called query analysis. Big tech companies are dominant in all of these essential inputs. In the context of the current paradigm of building large language models, there is no AI without big tech. With vanishingly few exceptions, every startup, every new entrant, and even every research lab is dependent on big tech. All of them rely on the computing infrastructure of Microsoft, Amazon, and Google to train their systems, and all of them rely on the data provided by these big tech companies. So what that means is big tech companies have bottlenecks with respect to the essential inputs necessary for development of AI applications. Second, the downstream AI applications. In addition to the essential inputs necessary for successful development and deployment of AI applications, big tech companies have complementary assets, enabling them to integrate their AI products and services into their existing ecosystems. So where are we going to first see AI? In the big tech ecosystems. Big tech firms will have significant competitive advantages over rivals because of the strengths of their positions in key markets and their ability to integrate their applications into existing ecosystems to the exclusion of rival AI products. There are many examples of such integration, but among the most obvious are big tech's enhancements in markets that they already have leading positions. In search engines, Google is using its own Gemini rather than others, Office Suite applications, social networking messaging, and voice assistance. Third, let me briefly mention that specific areas of immediate antitrust concerns. The two that I've mentioned thus far, there's not a lot of antitrust solutions to problems associated with essential inputs and self-preferencing AI applications to their own ecosystems. The antitrust law is just not sufficiently robust to deal with those concerns. But what we do see are a number of different areas of immediate antitrust concern and the difficulties associated with that. So what are enforcers doing right now, and what can we anticipate that they will do in the future? Well, essentially, enforcers are focusing on antitrust concerns in AI markets, particularly anti-competitive mergers, investments and partnerships that are designed to try to skirt merger review, monopoly abuse of upstream technology necessary to develop AI applications, and autonomous AI price-fixing behavior. Just a few examples. Enforcers are blocking mergers. NVIDIA, most famously, was blocked from purchasing ARM Limited by the FTC. They're also examining a host of possibilities of acquiring nascent competitors. So merger review is one of the more significant ones. There's a very clear signal from the FTC and the DOJ that they're going to be reviewing attempts to acquire nascent competition. They're also scrutinizing strategic investments, Microsoft's investment in OpenAI that created ChatGPT, Google and Amazon's investment in Anthropic that created Claude, and the so-called reverse acquisition hires of Microsoft on Inflection and Amazon of Adept. Rather than doing the traditional acqui-hire, where you basically buy a company because you want the engineers, what they're doing now to avoid merger review is they're not buying the company, they're essentially licensing the software from the company and then buying all of the top talent and removing all of the CEOs from Inflection and others and leaving a caretaker CEO at that company. So it's a so-called reverse acqui-hire. They're also looking at NVIDIA and its potential abuse of monopoly power with respect to its monopoly power in GPU technology. And then finally, something that is extraordinarily interesting is algorithmic collusion. The possibility is very real of autonomous price fixing, in which an AI application is given an instruction to profit maximize. And then the AI, with only those instructions, will behave in a manner consistent with collusion to the detriment of consumers and the benefits. It's already been papers indicating that when you tell an AI to profit maximize, they will reach the solution of collusion. And then finally, the fourth aspect of my paper is the competitive concern about China. And this is essentially a balancing of interests between antitrust concerns and national security concerns. And so the United States thus far is taking extraordinary measures to try to ensure that China does not have access to US technology. There's massive export controls associated with it. And then they also are imposing fairly strict rules on CFIUS investments, Chinese investments in technology in the United States. And then for the first time doing so-called reverse CFIUS, where there is restrictions on American companies investing in Chinese AI technology companies. And so one can see basically, as much as we're concerned about emerging antitrust threats, we're also extremely concerned about the national security threats, with the goal of making sure that at a minimum we're slowing the risks associated with Chinese deployment of AI applications for military use and for other uses. So I think I am done with my time. I'll stop there. Thank you.
Great. Excellent. Robin.
Thank you. I think we are sharing one live microphone. Since there have been a lot of labels thrown around, I'll start by saying I'm a techno-optimist and a techno-realist, although you may doubt the optimist part by the time I finish my comments. I'd like to start by congratulating Professor Alford for the paper, because I have to say it is without a doubt the best description of the AI industry that I have ever read anywhere. It is clear, it's cogent, and it's completely accessible for people who don't understand much about the industry. It was really beautifully done. And also for highlighting the problem that competition authorities have when we have new technologies. We have new products, we have new markets. It's difficult to adapt the tools to that, to understand their interrelationships as well, and that will be a struggle. I have to say that despite that, I am reluctant to suggest that governments step in unless I'm certain that the cure is better than the disease, and I have some doubts about that for the AI industry and competition authorities right now. Let me talk about one angle. Professor Alford set out some of the choke points in the industry. I'm going to talk about two of them here quickly. One is skilled labor and the other is computing power. So there is a shortage of the highly skilled people who know how to do generative AI, Gen AI, at a very high level. Nevertheless, it would be hard for me to imagine a circumstance in which I think it would be positive to limit the freedom of labor and the ability of people in Silicon Valley, to where much of this is happening, to move to different jobs. For anyone who studied that area, the freedom of labor within Silicon Valley is famous as having set the stage for an explosion of technology as brain power moved from one place to another in comparison to other places. The next is computing power. It takes an extraordinary amount of computing power to run, to train these generative AI systems and to use the generative AI systems. And so there is a limit to the amount of computing power that's out there, and it is concentrated in the hands of a small number of companies that grant access for a fee to others around. So again, I want to step back and say there's a choke point in computing power. Computing power is an essential input for generative AI now. However, technology is moving with extraordinary speed in the AI areas that we're talking about. There are let me explain this. Why do we need so much computing power? So when you put a query into Google Gemini or ChatGPT, what that system does, even though it's already been trained, is it runs that query through absolutely every layer of the program, of the algorithm that is set. And that takes an enormous amount of computing power to do. With the next query, even if it's a refinement of the first query you gave, the system begins again, and it runs the query all the way through every layer within the algorithms. It takes enormous computing power. However, there are architectures out there that are being used and that are being developed which would essentially learn. That is, it wouldn't have to run through absolutely every layer for every query and every time. If those actually develop in the directions that they might, who knows? But in that case, we wouldn't need the amount of computing power that we need now. So suddenly, a choke point is no longer a choke point. So if we act reactively and we run in to fix a choke point that might not be there tomorrow, I think that might be a problem for the approach we have. I also want to talk about now to the core issue here, even though I don't have much, I guess I do still have some time here, which is who benefits? Who benefits when U.S. competition authorities act on antitrust concerns? And that's where I have the greatest concern in this area. So pundits are quick to set out and to speak about, I think, what our prior speaker called Rosie the robot. That is the concern that around the corner we have to worry about rogue robots who will destroy humankind, or at least things that we hold dear. I have to say that I believe the greatest AI values today are likely to be human-generated within the AI field. In other words, we don't yet have to fear rogue robots, but we can't underestimate concerns about rogue states, rogue humans with AI tools in their hands, and I'm talking about existing AI tools. So that type of threat is here, or at least in its infancy, and it's something that Professor Alford referred to during his paper at the very end. So I want to set out a proposition that some people may find controversial, but I always believe there's value in saying things clearly and directly. I don't believe we're just in an international race for AI technology, an exciting competition where great minds worldwide will compete to design the latest, the greatest. We hope to run fastest in this race, just as we have with internet and smartphones. I don't think that's right at all. I think it's different. I think we're already in a new kind of Cold War. And I will touch on this subject lightly because it's a deep topic, but I think it's important to think about. So on military fronts, it's not hard to see the importance of drone technology, precision weaponry, and other military capabilities, not to mention capabilities to target or protect infrastructure, including water, power, transportation, and communication. The U.S. has an edge in this type of technology at the moment, both for civilian and military applications, but we would be foolish to think that our edge will necessarily last very long on the international front. Or as Eric Schmidt recently pointed out, that our military procurement system is well suited to AI innovation. It is not. On the non-military fronts, we face the potential for unprecedented and silent assaults on the foundations of democratic society. It isn't limited to an assault on freedom of speech. It is more deeply an assault on the deliberative process itself as a Jeffersonian ideal, as well as an assault on a variety of founding values and principles within this nation. So let me just try to give you a couple of quick examples. The mainstream press has highlighted the process that apps like TikTok and other social media programs do. So they don't just look at an individual's prompts, they examine beneath that The amount of time your eyeball stays on particular aspects, how much time you spend on the things that they are feeding to you, what aspects you spend time on, what draws your attention, where do they pause, where do they return, and then these apps use it to feed us things that we seem to react to, amplifying, enhancing those feelings. Our young people in general are endless guinea pigs being fed slightly varying diets until the observers figure out the exact amount of potion it takes to drive and sustain our reaction. Now, the mainstream press portrays this as a problem because it expands feelings, particularly enhancing depression, lack of self-worth, hopelessness in teens and young adults. I think that's true, but why in the world should we imagine that the only goals of these systems could be to reinforce and expand our own feelings? You can easily imagine the same type of techniques being used to drive and direct our feelings. There's some interesting research that if you want to convince people to take action, if you want to use what's called a nudge in social science, you want them to recycle. The best way to do that is to tell them that others around them are doing it. So perhaps showing us others around, feeling and acting in a certain way prompts our own behavior. And of course, that imagery that we are seeing may not just be created by humans, also by bots and by state-sponsored bots. Those types of messages shape societal views, and they've shaped their views not just on who is the latest singing star, but also on the democratic process as a whole and what people think about the democratic process. I'm just going to move this because I'm stealing your timer here. There was a fascinating article, which I don't have exercise, but I don't have time to tell you about, but perhaps another time in private. So what I want to say is that when we are in a wartime or a critical moment, generally technology and the government and industry work together to try to deal with those threats. So if our main approach to handling potential competition concerns involves things that may shackle those parts of our industry that are leading in this particular Cold War, or that breaks apart the pieces that give us, or those who have the large pieces that give us the ability to use the infrastructures that we have, I want to suggest that may be an area of concern, and that we should think about this. If we think about states like China, Russia, and Iran, and what they are doing with these programs, directing them at our own democratic processes, and how they can use those across time. So on that cheerful front, I yield the podium.
Great. So I'll just offer some quick remarks and then would love to hear from Roger. So on this, the landscape, I think the landscape set out in your paper on the legal front, I recognize, and I think you accurately display it. I might characterize it slightly different in that, yes, it is very difficult under current antitrust law to attack things such as Microsoft integrating their products into Word, where it would create perhaps a lot of consumer benefit because they have the scale to deploy that type of powerful technology to a lot of people who are already using their products. That's a consumer advantage in many ways, and I think your paper reflects some of those major consumer advantages when you talk about the massive GDP growth that could result from these technologies. GDP growth is created from productivity, and these tools, if they have that power, it's not going to be, they will be providing those benefits to others in order to get profits rather than just aggregating all of that money to themselves. So I think there is some challenges there. And frankly, on the sort of technical landscape that you lay out, I don't understand this industry. I don't recognize this industry landscape. I think when I think about something like the explosion of AI companies, we've seen 1,800 new companies in 2023 alone received investment. We've seen a skyrocketing of open source models. So when we talk about big tech, it's interesting, even on the constraints that we talked about on compute, it's not clear whether NVIDIA fits in there. Does OpenAI fit in there? Those are two companies that I don't think anybody 4 years ago would have called big tech. In fact, NVIDIA in 2022, I think their stock price was $12 a share. And due to their foresight about the massive need for massively parallel computation, they are now one of the biggest companies in the world. And so I think the industry landscape, I think, here to argue for antitrust action in this space, I think needs a deeper dive. I think there is a lot going on there. And in particular, I'll just add, in the open source space, the FTC, the current FTC, who you cite quite a lot in your paper, also talk about the big advantages of open source in the pro-competitive way. And so I'll leave it there because we're running short on time. So would love to hear your thoughts.
Yeah, so just a few comments about both of your reflections. I appreciate them. So I do think the bottlenecks almost guarantees that big tech will be controlling the future of AI. So even though there are dozens and dozens of startups, they're all going to be developing their applications within the architecture, the developmental frameworks of big tech companies. And so basically all of the AI applications are developing within the cloud storage structure and within the AI frameworks, the developmental frameworks that a big tech has created. So the big tech has created the foundation and the storage and the data, and then startups can build within that framework. But it's all within that framework, and that's why I think it's critical to think of them as choke points. That doesn't mean that antitrust authorities should do anything about that specifically, because it's not a monopoly status yet, right? And it's not price fixing, right? So it's hard to know exactly what they can do. The most that they can do, and it looks like they are doing, is fairly aggressive merger review. But challenging the acquisition of a nascent competitor is controversial. And in fact, when FTC tried to do that with Facebook, with one technology related to imaging, the court rejected it. So nascent competition challenges are difficult to succeed in. On the issue of data, the other thing I want to say about data is there's a very genuine risk that when the data is trained, especially when it's real trained with human interaction, that there's a very serious concern about content bias. And the content bias is real. I think everyone knows about the founding fathers and having different diverse perspectives, but they've also done analysis. And when you ask Gemini to generate an image of the Pope, they have a female Pope, right? That they just naturally generated a female Pope with the goal of being diverse and inclusive in that. Even more alarming than that is that there are Chinese versions of this, and the Chinese version of ChatGPT is called Qwen 2. And if you ask Qwen 2 to talk about what happened at Tiananmen Square, the tech companies basically will have embodied in their training all of the societal values of the CCP. And so they will tell you nothing about anything related to Taiwan, the Taiwanese massacre, the Uyghur internment camps, the status of Taiwan. Any sort of queries in those models get completely whitewashed by the Chinese chatbots. So what I'm trying to say is that there's a very genuine risk that unless we have multiple AIs with multiple different avenues for pursuit of the truth, we're going to get the content that is the preferred version of these companies. That's, I think, a very real risk. With respect to with downstream inputs, I do think that there is room for growth in basically very, very specific areas. There'll be healthcare examples, I think, that will be pretty significant, where there'll be brand new companies doing amazing things that are not controlled by big tech. But what I'm trying to say is the scale of AI applications is primarily going to be through the deployment of the preferred AI application of big tech. That's what I'm trying to say. And so to the extent the big tech company has an AI application that they're trying to push, then they'll likely prefer their own, even if it's inferior. And so you see that with Meta and their AI. You see that with Google and Gemini. It's definitely not as good as ChatGPT. And so what we see is basically some companies are using their own AI applications, and then other companies are licensing the AI applications of others. So Apple is the best example of licensing ChatGPT, even though they don't control ChatGPT. And then with Grok, X has licensed Black Forest Labs image generation. It's a German startup because they say it's simply the best. So we see basically, in some instances, really, really great startup companies are licensing their AI applications to big tech companies, but other companies, we're not seeing that. So I think for the sake of time, that's all I'll say.
Great. So Zvi?
All right, so I'm a copyright lawyer, and I heard Nate say at the beginning of the day he's going to play in the first 90 seconds of a podcast, and I got immediately nervous. You get clearance. This is being live streamed, so you get a license for the live stream? What about YouTube? How's that going to work? And worst of all, is he going to call me after this and say, okay, now what about that? So, of course, that was AI. But that raises different questions. What copyright does the Federalist Society hold in a video of this event if it includes an AI component? Would the Copyright Office of the Library of Congress let the Federalist Society register it for copyright? Now, for the past few decades, copyright protection has been automatic. But there are numerous reasons to register. This includes you get standing to bring an infringement action, allows for increased damages. In my article, I talk a lot about how the questions of what we now call AI go back much further than you tend to think. The first attempt to register an AI work was 1956, and the first successful one was 1957, although I'm not sure the Copyright Office knew that. These were both in music, and after that, there were a couple of others in other genres, and the Copyright Office put out a statement in 1965 saying, and I quote, "As computer technology develops and becomes more widespread, difficult questions of authorship are emerging. It is certain that both the number of works approximately produced or written by computers and the problems of the Copyright Office in this area will increase. The crucial question appears to be whether the work is basically one of human authorship, with the computer merely being the assisting instrument, or whether the traditional elements of authorship in the work were actually conceived and executed not by man, but by machine." That was 49 years ago. So last year, the Copyright Office put out guidance directly mirroring and quoting this 1965 guidance, saying that only works of human authorship would be registered and any AI authorship which is more than de minimis needs to be disclaimed. Now, this guidance is in active litigation, and a challenge was argued at the DC Circuit about 2 weeks ago. Given that this issue is of a much older vintage we tend to think, how do we feel about the fact that we haven't gotten an answer that's any better than the one we had 60 years ago? The one the Copyright Office put out 49 years ago. So I have 4 observations that I go through in this paper, and they're somewhat in harmony, somewhat in conflict. We'll see how this plays out. So this is the Federalist Society, and as we all know, the best thing you can always do is go back to the text of the Constitution. So this is what we variously call the patent clause, the copyright clause, the IP clause. It really depends who's paying the bill. So Article 1, Section 8, Clause 8 says that Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Generally speaking, science, authors, and writings have been interpreted to be the copyright provision, although that's a little controversial. So the first observation may be this simply isn't very hard of a problem. I mean, if we're going to look at the original public meaning of author, it seems pretty clearly to mean a human author. I find it at least highly unlikely that the founders were thinking about generative AI, and I think if you had asked them about an automaton, they would have said no. This copyright is one of those areas that really makes originalists out of everyone anyway, which is sort of fascinating all across the ideological spectrum. The problem with this, saying this is simple, we resolved it, let's move on, that while AI is still something of a toy, its outputs are becoming more and more commercially important, and simply waving copyright away likely isn't viable in the longer term. So, secondly, maybe lawyers are just really bad at thinking outside the box. In fact, that's not even really a question. We all know it's true. But it's a problem is that IP lawyers are so used to existing systems, they're unable to think of anything else. So maybe the solution for AI works that meets constitutional requirements of authorship, or even if they don't, we could also use a Commerce Clause, although that's a whole separate question, is some sort of sui generis protection, some sort of other protection which is not traditional copyright, but it would allow for some sort of protection for AI-created works. In addition, if we're going to draft that, we could also provide for some sort of more efficient compensation path for a situation where the AI work is clearly based on another work, which gets to the other question of AI, which I'm largely avoiding in this paper, is AI training infringing and AI outputs infringing of existing works. The third point I want to talk about is also somewhat related, which is copyright law is old. The current U.S. copyright law was revised a mere 48 years ago, although it was drafted more like 66 or over years ago. But if you look at the bones of that act, they date back to 1909, 1831, 1790, and in truth, all the way back to the 1710 UK Statute of Anne. This is a 300-year-old statute at this point, and we're trying to figure out how AI-created works fit into that. Now, the technological pressure on the copyright statute has been going on for a long time. Really, ever since photographs, it's been a question of, okay, maybe art photography author in the sense of the Constitution. Computer programs. Do you know we're still registering computer programs as literary works because they didn't have a better idea in 1963? So maybe AI is a point where the dam just breaks. Maybe AI is a point where this 1710 statute as amended simply has to be at least supplemented. And in truth, we already do that some. We have protection for semiconductor mask works, for instance. Maybe we ought to broaden that out to be for AI works, going back to point 2. And finally, maybe AI has something to tell us about the balance of copyright law more generally. Maybe AI really teaches us about just how precious human authorship is. What does the Constitution say? Remember, there is something important about promoting the progress of science by protecting the writings of authors. Maybe this specific constitutional objective is something where we're saying, oh, look, actual copyright needs to be strengthened around what we might call core authorship, the writings of authors, and we should stop trying to shove everything into it, like AI creations. One really interesting thing about AI training is that this is a problem that the internet is largely how AI is trained. It's becoming increasingly polluted by AI content, which is essentially useless, as I understand it, for AI training. That's one of the reasons you may have heard about when Reddit went public, and it went for a lot of money. Why does this webpage where people just talk have so much value to the stock market? The answer is, it is one of the last refuges of human-created content. Human authorship is valuable, and AI is being built on the backs of human authors, and we need to take more seriously what that really means. I think I'm going to break a little early because I'd love to hear some more questions if we can get to them.
Sure, great. Excellent, thank you, Zvi. Just some quick reactions from me, and then Robin, if you have any, please jump in. So at the very highest level, I said this to you at the beginning, this is a refreshing paper for me because so much when I hear about the debate around copyright and AI, it is around the training data and not on the authorship side. So this really opened my eyes. In addition, I got to discover some new computer-generated music and computer-generated art that goes back decades at this point, and I found it really interesting as a computer scientist myself. And you point out in your paper that maybe perhaps the Copyright Office actually got it right way back in 1965. And I think there's a lot of echoes in your paper from the first panel that talk about, this is really about humans and human rights here. And the other echo that came through to me, I think Bartlett captured this somewhat as well, is that the discussions of AI are very old as well, and their ability to create. I know as a computer scientist, very, very commonly when somebody refers to AI, I just put in my head that they're just basically saying computers, and that's more or less right. When I look at legal definitions of AI, almost always they are basically indistinguishable from basic computing. And we had a lot of hints about that around all the algorithms that are in our phones. And so this debate is old because AI is old, and it is basically computers in many cases. And so I really appreciated that you talked about that particular aspect, the ancient, almost ancient, in computer terms, it is pretty ancient, origins of this issue. You know, your paper talks a lot about examples of other new technologies. The one I found the most fascinating was the records. Recordings of music were not copyrightable. I didn't know that for 60 years after the technology was invented, and that's really interesting. I had no idea, and I would have liked to see some more lessons pulled out from how that transition happened, why it happened that way, and what does that mean about AI, and should our rush in one direction or the other here. But my really big question, and I'm glad you end your paper on it, and you just ended your presentation on it too, is on the constitutional language around this. And you point out that the Constitution says to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right. And you zoomed up to the means, and I wonder if we should zoom all the way up to the ends. You zoom up to the level of, hey, we're going to promote the progress of science and the arts by protecting the rights of authors. And I wonder what it means in this context to zoom all the way up to the ends and say, what would most promote the progress of science and the arts in this space? And in which ways can we protect authors that promote that? And are there ways that we might protect authors or maybe AIs in a way that wouldn't promote that? And so some engagement with the purpose of the copyright clause as stated in the Constitution, I think would be really interesting to me as well. So I will stop there. Robin, I don't know if you had anything more to add, and I'd love to hear Sweets.
I'll just try to do this quickly. So first, I'm going to take exception to the notion that lawyers can't think outside the box. I'm sure there are many of you in the room who would agree with that. And I will also say I loved the closing where you were talking about whether AI may break the copyright system. I hope I'll have your permission to reference yours, because I have a book draft, final draft due in 2 weeks, on whether AI has the potential to break all of intellectual property. But as I've listened this morning, I think I can, in like 1 minute, tie together so many of the different threads we've heard, both in terms of copyright and in terms of intellectual property that copyright represents, and in terms of the competition issues we talked about, and even in terms of the First Amendment rights and who holds those rights and in what circumstances. Because I want to step back and say that AI is not, it's not a thing, it's not an entity, it's not an it. AI is a way of going about doing something, and we have products that use that way of going about doing something that are out there for people to use, for humans to use, but they're just tools, they're just ways of doing things. So the question really is, what are we doing with this thing that humans are using? And that, I think, is a question that we have to apply in so many different ways, and it gets confused by the language that we use when we talk about AI or an AI. It suggests think about using math or certain types of math. It's a way. So if you think about it, again, going back to the competition setting, think about Genentech. Genentech invented a way of what became cloning cells, a way that you take existing cells, turn them into a line that went infinitely, and then begin to try to manipulate that line. So they owned that, a choke point. But their approach to it was to license it widely for very low amounts, and it spawned an entire industry. That's our biotech industry and most of the drugs coming out now. So the question is, what do humans do with those tools? And then how do we want to approach that from different types legal systems.
Great. So Zvi, would love to hear your thoughts on our remarks, and then we will open it to the audience. So get your questions ready.
Yeah, so the terminology is fascinating, and it's sort of a backdrop, I think, for everything we're talking about, because calling it AI is a fairly new thing. If you looked at what they were talking about, these experiments in composing music in the 50s, and 60s they called it algorithmic composition or stochastic composition. Apparently, about 20 years ago, it was called computational creativity. It's just machines making something which looks like human authorship, and what we call it is really, I mean, whether or not it's actually intelligent, does the term intelligence obfuscate, inform, or both? And I don't quite have the answer there, and a paper about copyright probably is not going to be a place where we resolve that, but it's something definitely worth talking about. You know, I really should talk, so I've written separately about the sound recording issue. In 1908, the US Supreme Court held that a piano roll is not a copy of musical composition because it's not readable by a human in the ordinary way. And for a series of really antitrust reasons, they set up this mechanical license where you're allowed to make a cover song however much you want, because there was concerns about literally a monopoly on music licenses in a player piano market by the Alien Company. And so they set up instead this automatic license, and they excluded sound recordings from copyright. That went on for 60 years. By the end, it wasn't working. And I'm sorry to dispel any images of the 60s for you, but if you played a record in a jukebox in the 60s, odds are it was a mafia-produced bootleg rather than a properly pressed record. There was a real problem of piracy. You started having state laws trying to deal with it, but of course that was of limited use. And it may be that, and we saw in the first panel, discussions about using state laws, and also Judge Vaden's introduction about the Elvis Act. I'm like, well, state law is great, but there's a point where it may not be enough, and records might be an example of that. As for the ends and what we're doing to promote authors, it's a really interesting question. I mean, that's a push-pull in copyright. You've had this debate about copyright term extension, for instance, about the ends and what the clause means, and it's a difficult one because, and what does it mean to promote the progress of science? I mean, talk about the view from 10,000 feet. How can Congress, is that a carte blanche for Congress to promote the progress of science? And I think it makes sense if you view that clause as being limited to the writings of authors and the inventions of inventors. And I think that limitation has to matter. And I do think I think human authorship has to be a break point. Because if you don't, then what's left? You've effectively given Congress a really broad carte blanche, at least in this area. And yeah, I think it's a broad question.
Yeah. Well, it's the level I operate at in the copyright space, so that's what you're going to get from me. I would love to have questions from the audience. We have a little bit of time, I believe, so step up. I'm sure somebody has a thought provoked by these two terrific papers. I mean, I will ask questions if nobody in the audience does, because I have more.
Don't worry, I will too.
Yeah.
You put professors up here, we'll definitely come up with something to say.
Well, maybe I'll, just really quick then, I share Professor Alford's concern around the shaping of models through human reinforcement through human feedback and other ways that the content in there can be shaped. And in some ways, competition is obviously a great solution to this. We do have in the open source space a lot of open source models. I think Hugging Face has 450,000 different trained models. And so if you want a model that takes your particular point of view on the world, it's relatively available at this point. And so you may be running it on a back end from any one of the 12 plus major infrastructure providers who do compute in this space, or you might be running it on your device. A lot of Apple has partnered with OpenAI, but they're also they're really focused on on-device AI, which would be their own model that's not the OpenAI one. So there's a lot happening in this space. It's hard to keep up, but I'm curious about how you think about that interaction between competition and model bias.
Yeah, it's a great question. There's certainly a lot of available options, Hugging Face list of all the different LLMs. You're right, there's a very, very long list. What I'm trying to suggest is, are you as a consumer going to go to that long list of those different LLMs that you've never heard of? Or are you going to simply click the Siri button on your iPhone and use the chatbot that Apple has chosen to give you to provide the answer? And the answer is, because of the power of big tech in adjacent markets, the answer is you're going to use the AI that they are providing to you at your fingertips. And so it's really critical to get the right answer about what Gemini's answer is, what ChatGPT's answer is to these questions. And there was empirical research about the way these AI models are fine-tuned, not the basic training, but the fine-tuning, where they said that the generative answers from the AIs lean left by political orientation tests, likely due to the unintentional byproduct of the annotator's instructions. Essentially, the idea is that the fine-tuning is happening within a monoculture, and that monoculture reflects the answers. And so we've already faced that in antitrust with voice assistants, where you go to a voice assistant in your home, and there's only one answer that is available to be given by the voice assistant. And so what's going to happen is a version of that with AI applications. And so I think it's really, really critical. Now, it might be what you're saying is eventually, similar to browsers, we're going to have a Safari and a Mozilla and a Chrome and DuckDuckGo versions of different AI chatbots, and you can choose the one that you prefer. And if that happens, then at least if there's a multiplicity of voices, then we might have more freedom from bias because of competition. I agree with that.
Perhaps I could round this out with a question for Professor Rosen. Simply say, you go back to the language of the Constitution and promoting the progress. And when I think about that language, it talks about progress and it doesn't speak about authors. So I understand when your paper, the context in your paper talks about that these are about authors, but what about, but authors aren't in there. The Constitution gives Congress the right to create systems to promote the progress. We use authors and their rights to do that promotion, but maybe it isn't about authors.
I think it depends if you, in terms of, the word science has always been difficult because the general understanding of the term science is that it's an archaic usage, which means essentially human knowledge. Not just science as we think of it now, but all human endeavor, almost like all fields of expressing information, everything from literature to navigational charts and everything in between. And so the question which has bedeviled a lot of these cases is the so-called progress clause, which another thing where if your client is paying, you'll call it that. Is it a preamble? Is it a unified clause? How are you to read progress of science and the useful arts by securing? And of course, securing, is itself an interesting word, this sense that it's something pre-existing, and it's not just something which Congress is creating, but it's something that's there, and they can create these means to secure it. I tend to think that reading the progress of science and useful arts without looking at the means by which it prescribes, I mean, it's sort of like, and it's a bit compared to the Second Amendment, which I don't know by heart, I'm sorry, but a well-regulated militia being necessary, blah, 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 the right to bear arms shall not be infringed. And And a lot of Second Amendment jurisprudence, there's this question of, oh, okay, so it's not a well-regulated militia, so you can't have your gun. And of course, the answer to that has been no, that's not what it says. And I think the general trend lately has been to do a similar interpretive approach to say the promoting progress of science and useful arts looks to the means. It is not freestanding as a general right to promote, but there's no question that it was a concern. And if you look at what they were saying, hey, look, we want people to create stuff. There was a real concern that an American flowering of invention and authorship was vital to the flowering of America more generally. And that, I think, was a progress they sought to promote. And of course, the fact that you couldn't get a copyright if you were a Brit for over a century afterwards is part and parcel of that.
I see we have a question.
Maybe a small question. I wondered if Professor Alford could elaborate on this question of AI going out to maximize profits. I don't understand that in practical application.
Yeah, so basically, everyone says we want to develop AI with a priority towards safety, right? And the principal concern about safety is paramount in all of the warnings about AI. But what I'm trying to say is, when you recognize, if you're a big tech developer, the upside potential of AI, it's simply irresistible to go as fast as you can. One AI leading expert predicted that achieving general AI intelligence would result in 10-fold increase of global GDP from 76 trillion to 750 trillion per year, an increased income stream of 13.5 quadrillion. So when you see this giant golden carrot in the distance, you're going to basically go as fast as you possibly can to be first. Sundar Pichai says that in a transformative area like this, the risks of underinvesting is dramatically greater than the risk of overinvesting. So they're going as fast as they can and basically say, we'll figure out the problems in the future, is essentially what I think is the attitude of most big tech companies.
So I have a question for Professor Alford and I guess Professor Feldman. I guess everybody other than, it's not copyright. But so many people argue that the greatest utility from these large language models will be in refined models using smaller data sets that are very focused on specific applications. And so that suggests that there may be a very heterogeneous utility and I guess you could say marketplace for the technology. And I guess what I would ask from an antitrust standpoint, how would you go about defining a market when you have, you're really talking about a technology not yet at this stage of useful products. How would you think about that?
I completely agree with that. I do think that there will be tremendous innovations in specific industry segments using smaller language models for very specialized use cases, for sure. We're going to see that in healthcare, for example, almost for sure. And that's very exciting. That's a wonderful thing, and we don't know who's going to be the ones that are generating that. But obviously, I would think that the answer to market definition, you would not say that a large language model designed to solve cancer, a certain type of blood cancer, is going to be in the same market as an AI application that is used for voice assistance. It wouldn't be the same market definition. So there's going to be multiple new markets that are generated from this, and the race to be first in curing certain kinds of diseases it could be smaller data models. It doesn't necessarily require massive data models, especially ones that are mathematically inclined. A lot of the work on export controls is to restrict GPUs from China, and China is developing small language models because they don't have access to GPUs. So they're doing this alternative approach because they just don't have access to the computing power necessary for large data training. And so that will be the future for sure. There will be a lot of that, and then in each individual case, you'll do your own market definition.
Yeah, and I'd just add that, I think that shows that some of these data barriers are not inherently big tech advantages, right? Big tech doesn't have that set of data. And in fact, social media data is not particularly it's not clear what the model that you would train on social media data that would be good, other than perhaps advertising. I think this is another example of where the use of the term AI, because it's such a broad, general-purpose technology, is quite confusing to the discussion. Just because both have AI in the term doesn't mean they're in the same market. I think in that way, some ways, it's an even bigger problem than just saying big tech, which, you know, those companies are in quite a lot of markets and not all the same. So I think we are out of time, but
I'll give you 30
I will
seconds.
Yes, yeah.
Because your question touches on how do you define markets when the markets themselves are evolving rapidly. And my short answer to that question, which I've given before, is we need a robust second look policy. That is, it allows competition authorities to say, go ahead and we'll take a look at things as things evolve and we'll see what happens.
Well, thank you very much to the panelists and especially to the authors of these great papers. And as they come out, I hope you all read them.
Yes, thank you very much, Neil, and to our panel. Excellent discussion. Just a logistical note, we have a short break now at 12 o'clock in Palm Court, which is the room across the hall. We will have lunch prepared, and you'll bring your meals back in here. And we'll have lunch from 12 to 12:30, and then we will have our next roundtable discussion starting back in here at 12:30. So we're out for a brief break, and thank you again to our panel.